Hello, everyone. Hello. Good evening. My name's Colleen Shogan. I'm the Archivist of the United States, and I want to welcome you to the National Archives. Of course, as the Archivist of the United States, my job is to preserve, protect, and share our nation's records. With 13.5 billion records here at the National Archives, we certainly have a lot of stories to share and to tell. But the story of our nation really begins upstairs with the Declaration of Independence. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them to another and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. Notice what words appear in the first paragraph of the Declaration: separate and equal. Separate but equal was a cruel play on those words of the Declaration, and Brown v. Board reclaimed those words. So I can't take credit for that insight. It comes from my friend Danielle Allen, who is a political scientist and a philosopher at Harvard. And it comes from a conversation that I had with her on the meaning of the Declaration of Independence. She wrote a very thoughtful book about the Declaration, and I was privileged enough to interview her about that book, and that insight came up and always stuck with me about the importance of those words. The Brown decision was certainly a pivotal point in our nation's history. With his victory, Justice Marshall laid the groundwork for the civil rights movement and our ongoing pursuit of a more perfect union. He spent the rest of his life building upon that foundation. As he said in one of his last major speeches, nearly 40 years after Brown, the legal system can force open doors and sometimes even knock down walls, but it cannot build bridges. That job belongs to you and me. Afro and white, rich and poor, educated and illiterate, our fates are bound together. Here at the National Archives, we hold the records of the 5 cases that constitute Brown and the many civil rights cases that came after it. So I'm glad we've come together this evening to hear from 2 jurists who personally clerked for Justice Marshall to explore the impact and legacy of Brown through the lens of 70 years of history. It will be a great conversation, and really a fitting conversation to have here at the National Archives. I want to thank the National Archives Foundation for their generous support, and also for Verizon for sponsoring this program and bringing us together this evening. Now I'm going to turn it over to our National Archives Foundation Chair, Secretary Rodney Slater. Thank you.
Thank you, Dr. Shogan. By the way, today is the first anniversary of Dr. Shogan's service as our National Archivist. The first woman to hold that post, and she's doing a tremendous job. Let me also acknowledge William Minor, who is the counsel for the Archives Board, and also Riley Temple. Riley is a former member of the board and was very instrumental in helping to secure a number of our speakers for tonight's program. And so Riley, we thank you, and William, we thank you, and to the other members of the Archives Board, we thank you for your leadership. My name is Rodney Slater, and I am the chair and the president of the National Archives Foundation Board. The foundation is the nonprofit partner of the National Archives. And for over 30 years, we have supported the incredible work and the important mission of this agency to provide public access to its vast holdings and to increase civic engagement with the citizens of our country. Programs like tonight afford us an opportunity to not only point to big events like this particular case, but also some of the untold stories of individuals who were involved and who have been involved in moving our nation forward as we seek to become a more perfect union. Before going on with my comments about the specific court decision tonight that we'll celebrate, I'd like to introduce an individual by the name of Kenneth Miller. Mr. Miller was a young student in July of 1952. His mother, Louise Miller, actually sued the District of Columbia Board of Education because he needed the assistance of being admitted to Kendall School for the Deaf. Mr. Miller is with us tonight, along with his wife, Carol, and other members of his family, and we'd like to just acknowledge him and the members of the family. Again, programming like this allows us to focus on big cases like this, one of the most important cases decided by the United States Supreme Court, but also individuals, some known and some unknown, and to tell their stories and to acknowledge them and to lift them up that we might be inspired by their example. Tonight, we celebrate the 70th anniversary of the landmark court decision, Brown v. Board of Education, and we discuss its legacy, the importance of this decision. For it was 70 years ago tomorrow that United States Supreme Court Chief Justice Earl Warren delivered the unanimous decision, the unanimous ruling indicating a critical turning point in our nation's history. It signaled an end of legalized racial segregation in schools of the United States, overruling the, quote, separate but equal principle set forth in the 1896 Supreme Court case, Plessy versus Ferguson. The foundation would like to also thank Verizon for its support of the National Archives and its mission, again, to engage our citizenry and to tell the untold stories and sometimes familiar stories of how our nation has come to be the nation that it is today. I now have the pleasure of introducing Tony Lewis. Tony Lewis is the Vice President of Public Policy at Verizon. Tony is responsible for shaping and advancing Verizon's public policy, and he directs Verizon's philanthropic activities in this region of the U.S. He serves on various boards, including Fight for Children, the Alvin Ailey American Dance Theater, Johns Hopkins University Carey School of Business, and KIPP DC. KIPP, as you know, is a network of high-performing public college preparatory charter schools which serve under-resourced communities across Washington, D.C. Mr. Lewis is also the chairman of the board of directors of the Washington Nationals Youth Baseball Academy and the former chairman of the board of directors of the Greater Washington Board of Trade. Ladies and gentlemen, please join me in welcoming Tony Lewis to the podium.
Thank you, Mr. Secretary. Good evening, everyone. Yes, you made a wonderful choice of being here this evening. You can already tell how special this is going to be. It's special for me because Mr. Secretary introduced me. That is one I can write home about. I want to quickly say a big thank you on behalf of Verizon, but I want to start with this. The thought of only being a creature of the present and the past was troubling. I longed for a future, too, with hope in it. The desire to be free awakened my determination to act, to think, and to speak. That was Frederick Douglass. Those words rang true to me when I read them this morning because of what we're experiencing tonight here. This partnership, this opportunity for Verizon to stand before you and partner with this historic place is all based on the same fundamentals, the values that we hold as Americans. The opportunity to connect our citizens around the world with this amazing place, with all of the data that you've heard about. And, as Mr. Secretary said, engage, one of my favorite words. Because at Verizon, what we do day in, day out is find ways to ensure that you, our customers, our consumers, our friends and family and neighbors, have the opportunities to engage in the ways that you want and need to, and to have the opportunities to see this information, to experience this information, and to take this information in any place that you'd like, in any form that you'd like, as much as you'd like. So there is no better partnership for us than this partnership with the archives. I want to thank the entire staff for the opportunity to do this. They are marvelous. I wish you could meet them all. And we're looking forward to many, many more opportunities to experience these types of monumental opportunities to celebrate something as important as this decision, which literally placed me in this position to speak to you tonight. Thank you. And so next I have an opportunity to introduce heroes, and I literally mean heroes. It's my pleasure to introduce our distinguished panel. We are joined by two individuals who served as law clerks with Supreme Court Justice Thurgood Marshall. Sheryll D. Cashin is the Cormac Waterhouse Professor of Law, Civil Rights, and Social Justice at Georgetown Law. She is a frequent speaker, contributor and writer, and an author of 4 books. Her most recent book, White Space, Black Hood, examines the role of residential segregation in producing racial inequality. Randall L. Kennedy is the Michael R. Klein Professor at Harvard Law School, where he teaches courses on contracts, criminal law, and the regulation of race relations. Mr. Kennedy writes for a wide range of scholarly and general interest publications and has authored several books himself, including Race, Crime, and the Law, for which he was awarded the 1998 Robert F. Kennedy Book Award. And moderating tonight's panel is the Honorable Michael K. Powell, President and CEO of NCTA, the Internet and Television Association. Chairman Powell is the former chairman of the Federal Communications Commission and currently serves as the chairman of the Mayo Clinic Board of Trustees, chairman of the William and Mary Foundation Board, and vice chairman of America's Promise Alliance. Please welcome the panel to the stage.
Wow, what a great crowd. Good evening, good evening. Welcome to tonight's program on the eve of one of the most monumental Supreme Court decisions in the history of the United States, Brown versus Board of Education. And I am pleased and honored to have the opportunity to discuss this important case and its history with two of the most distinguished professors in this field, Randall Kennedy from Harvard Law and Sheryll Cashin from my alma mater, Georgetown University Law Center. All right. So we have a limited amount of time and a lot to cover, so I do want to get started. So we need to set the stage. In the years following a terrible civil war in the United States, in a very short period of time, the United States adopts three monumental constitutional amendments. The 13th Amendment abolishing slavery, the 14th Amendment providing the equal protection of the laws, and the 15th Amendment guaranteeing the right to vote. You can imagine this didn't necessarily go over well in parts of the country. And since we're at the archives, I think understanding history is important. So help us understand what was going on in this period, and what were some of the ways that states were working to circumvent what was this new muscular federal authority in the intervention of their daily lives.
I want to defer to the man who taught me race and racism, American law on this part. Thank you.
Well, it's wonderful to be here this evening. So you're asking about the Reconstruction era and what happened. So there was a Civil War which put an end to slavery, and then the party that prosecuted the Civil War, the Republican Party, was successful in spearheading three constitutional amendments. You mentioned the 13th Amendment does away with slavery. The 14th Amendment does a variety of things. One of the things that the 14th Amendment does is, for the first time in American history, determine who is a citizen of the United States. In 1857, the Supreme Court of the United States, in Dred Scott versus Sanford, said that African Americans could not be, under any circumstances, citizens of the United States. Well, the 14th Amendment changed that. And the 14th Amendment also stipulated that all states had to provide all persons the equal protection of the laws. And then there was the 15th Amendment. The 15th Amendment said that the states could no longer exclude people from the ballot on the basis of race, color, or previous condition of servitude. Now, that was a tremendous amount of reform, and that tremendous amount of that reform effort triggered resistance, much of it violent resistance. And the fact of the matter is we're still in the grip of that violent resistance. And I think that's the backdrop to our story here.
Yes, yes.
Can I add
Yeah,
one
please
thing?
do.
So the 13th, 14th, and 15th Amendment was a compromise, a coalition of radical Republicans, my heroes, Thaddeus Stevens, Charles Sumner, who I learned about in your class. That's the first person who introduced me to him. These guys were ready for black equality, but the moderates, the moderate Republicans were not. And so basically what they coalesced around was suffrage, and the idea was, well, if we give the black man suffrage, they can protect their own rights through politics. And there was some debate about civil rights versus social rights, right? And so not everybody in the Republican coalition was ready to accept the kind of equality like, going to the same schools and those kind of things. So that was still contested despite the fact that we had the 13th, 14th, and 15th Amendment.
Yeah, that's
I'm just going to say, picking up, I think that you're absolutely right. You used the word compromise. So the 14th Amendment is very central to our concern tonight, Brown versus Board of Education. And the 14th Amendment was very much a matter of compromise. So, for instance, there were some people who wanted the 14th Amendment to say that states would be prohibited from drawing racial distinctions. There were some abolitionists, for instance, who took that position. The Congress, the framers of the 14th Amendment were not willing to go that far.
Right.
And so they gave us what we currently have, which is a very ambiguous proposition, the equal protection of the laws. Well, that can mean a whole lot of different things, hence our dispute.
And we've been fighting about it ever since, to this day. What do those 4 words mean? Right. 5 words.
It's
right.
interesting, Sheryl, you highlighted this question in the compromise about social equality, which really finds its way into the predicate case of Plessy. So the state of Louisiana passes a statute in which it makes it unlawful for blacks to ride in the white cars of trains or whites to ride in the black cars of trains. And Homer Plessy intentionally boards the white train, is ultimately charged, goes through a series of trials, and we land in the Supreme Court in this relatively famous opinion of Plessy versus Ferguson. So tell us a little bit about the court and what it held and what it found in the case of Mr. Plessy.
So first thing I want to mention is that Homer Plessy didn't just do this on his own.
Right.
He lived in a neighborhood of activist black people, and there was a committee that decided they wanted to do this, and they recruited Homer Plessy. There was a really interesting lead lawyer in the case, Albion Turgey, who was, you can Google him, he's a really interesting figure, but a white guy who was down with black freedom well before a lot of other people. And he's the one who introduced this idea that justice should be colorblind here. So what did the Supreme Court hold famously? The majority held that black people could ride in the black car, and so they were formally equal with whites who had the white car. And Justice Harlan famously dissented in that case. I'll let you add.
Just one thing, we're talking about segregation. And segregation was a cruel lie. And Justice Harlan, in his dissent in Plessy versus Ferguson, really does do a great diagnosis of the cruel lie of separate but equal. The idea behind it, and it had a real grip on the American legal imagination for a long time. The idea behind it, the theory was, well, this is not a violation of the equal protection law because everybody is operating under the same law. So in Plessy versus Ferguson, white people cannot be in the same car with black people. If a white person wants to be in the ride with a black person, they can't do it. If a black person wants to ride with a white person, they can't do it. Nobody can complain. They're all under the same law. They're all being equally restricted. That was the theory. And, it seems to me that one thing that we ought to keep in mind is how powerful an idea that was. From 1896 to 1954, that's a long
60
time.
years, yeah.
That's a long time. And, if you ask the question, who were some of the people who were flummoxed by that lie? Well, Oliver Wendell Holmes Jr., Justice Oliver Wendell Holmes Jr., Louis Brandeis, and the list goes on. So, this idea was a very powerful idea, and that's one of the reasons why, Brown versus Board of Education is so important, is because the justices in 1954 really had to overcome a lot to reach the conclusion that they reached.
But I want to point out really quickly, people got to ride where they wanted to during Reconstruction.
Right.
In New Orleans.
This was a clawback.
Right. People got to ride, so black people had been riding on the trains. The schools actually were integrated in New Orleans during Reconstruction. So it's a clawback, and when the court decides this fake principle, it was particularly fake because people in New Orleans had been used to mixing, right? It encourages the proliferation for the next six decades of Jim Crow laws, right? This is like the beginning, but Jim Crow politics becomes like the only game in town. So everybody is falling over themselves. It's like, well, I'm going to segregate, I'm going to make so that black people and white people can't play checkers. And if you vote for me, I will segregate the books. I learned this in your class. Some schools even required that the books that children learned had to be segregated. And so that was like the central organizing principle in Southern society for 6 decades, and it dominated the politics.
We'll say this, though. what was the case that first announced separate but equal? It wasn't a Southern case. Boston.
It was Boston, but
Roberts versus City
yes,
of Boston.
yes, Boston in the 1850s.
1850.
Yes.
Law professors start
Yes.
fighting. You gotta
Okay.
tell them.
Now I teach that case. Let me just say, Charles Sumner and Robert Morris, a black lawyer, and Charles Sumner fought that case. They lost, but within 5 years, they succeeded in getting the legislature in the state legislature to repeal it. So anyway.
So let's move forward.
Yeah, move forward. Law nerds, law nerds.
Law nerds. So yeah, 7-1 decision, a single dissent, famous dissent. I pulled out one quote from that case, just gives you a flavor of it. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. Inherently rejecting the idea that the law would try to cure problems of social discrimination. And as Sheryl pointed out, we have this enormous 6-decade period of Jim Crow laws that our parents, at least my parents, grew up in. My mother grew up in Birmingham, Alabama. My parents told me many stories of not being able to stay here or drink from that water fountain. That's important to remember. That's not a generation ago. That's one generation ago. So we fast forward nearly 60 years, and we're on the doorstep of Brown, where the Supreme Court is going to be asked anew this question, whether separate but equal is unconstitutional in the context of public schools. And of course, the man who will argue this case, a lion of the law, and your former boss, later Justice Thurgood Marshall. Before we get in the case, let's talk about him. Tell us about him. What drove him in this work? How did he strategize about getting to the Supreme Court? He did a lot of work prior to this case to set the predicate for the court's case. You all got to spend some time with him. Tell us about it.
I'll be happy to talk about Mr. Civil Rights, who in my view is the greatest lawyer in the history of the United States.
Amen. Yes.
Just quickly, though, before that, I want to pick up on a point that Secretary Slater mentioned at the very beginning of these proceedings. Because Justice Marshall, I mean, we all know Justice Marshall. Justice Marshall was the Solicitor General of the United States. Justice Marshall was a Court of Appeals judge. Justice Marshall was 1/9 of the living American Constitution as a justice of the Supreme Court. He got a lot of plaudits during his lifetime, as he should have. There are other people, however, who enabled Justice Marshall to do what he did. And there were other people who enabled the Supreme Court to strike a blow for decency. And those other people often do not get much attention at all. I just want to mention one. I'm going to mention one. I'm from South Carolina. One of the cases of Brown versus Board of Education, Briggs versus Elliott, Clarendon County, South Carolina, there was a man named Harry Briggs and his wife, Elizabeth Briggs. Harry Briggs, very modest man, worked in a filling station. His wife was a maid. They became plaintiffs in Briggs versus Elliott. Briggs's boss, who was actually a pretty decent man, says, Harry, I read in the paper that you're a plaintiff in this case. You know, I can't employ you if you're going to be a plaintiff. So take your name off of it. Briggs refused. He was fired. His wife was fired. Reverend Delane, who was really the spiritual guardian of the plaintiffs in that case, was run out of South Carolina. These are the people that really sacrificed, and all too often we forget about them. It's people like that who are always beginning things. A case that the justices don't begin anything. The justices are always there as sort of ratifying things that have begun. It's these people who actually got the ball rolling. And they did have a great legal guardian, Mr. Civil Rights, Thurgood Marshall. And I'm going to be quiet. All I'm going to say is it was one of the great privileges of my life to be able to work for him.
You're here.
Wow, how do I follow that? Same here, same here. I clerked for Thurgood Marshall in his last active year on the court. But let me just quickly answer your question for the benefit of the audience. And there are other lawyers, Spotswood Robinson, Robert Carter, Constance
Coleman.
Baker Motley, there are other people who were on this team. Thurgood Marshall was the chief oral advocate. I always like to tell my students that he argued 32 cases before the Supreme Court and won 29 of them. Many of the ones that he did win when he was the chief legal counsel for the NAACP were knocking down planks in Jim Crow. Now, how did he become Thurgood Marshall? The quickest story is I credit, or academics who follow this story credit Charles Hamilton Houston. Charles Hamilton Houston, who graduated, was he the valedictorian of his class? I know he was on the Harvard Law Review, but I know he was the valedictorian of his class in Amherst, right? Harvard Law graduate. He was the dean of Howard Law School. He remade that law school into a civil rights firm, his attitude was, if you come to Howard Law School, you will work harder than you ever had, and the role of a lawyer, a Negro lawyer, that was the term then, is to be of service to his people, and either you're going to be of service to your people or you're going to be a parasite. And that was what he said. And Thurgood Marshall, under his tutelage, he kind of played around when he was an undergrad. He got very serious in law school. He graduated first in his class. And he and Charles Hamilton Houston kind of invented the civil rights law firm. And they started filing cases together. And it was really Charles Hamilton Houston who had this incremental strategy. His thought process was that Black Americans, Negroes then, were not ready to protest. And he felt like they had to go slow to get to the point where our people were willing to be plaintiffs, were willing to challenge Jim Crow. So they started incrementally, and they had won some victories, particularly at the graduate school level, particularly involving the University of Texas Law School. They got the court to say, in that case, Sweat v. Painter, right?
Yes.
They got the court to say that separate is inherently unequal, and so the principle was there. And because there were people like the Briggs family and Linda Brown's family and others willing to put their children on the line and contest, they eventually got to Brown.
Yeah, it's interesting that he pursued graduate education first. It's interesting in the University of Texas case, the holding really was that the two institutions were unequal. Texas had hastily stood up a black law school, not having one, in an effort to cure their problem, and the court ultimately said it wasn't equal. So we get to...
Can I just interrupt?
Yeah.
This issue was really quite personal with Justice Marshall. He was from Baltimore, Maryland. Mm-hmm. He goes to Lincoln University, predominantly, historically black institution, as an undergraduate. He comes back, he wants to be a lawyer. His family lived in Baltimore. It would have been very easy for him to have gone to the University of Maryland Law School. Mm-hmm. He could not attend the University of Maryland Law School because it excluded blacks. That is what prompted him. It's one of great irony. It was probably a good miss, because then he comes to Howard and falls under the sway of the great Charles Hamilton Houston. Now, Thurgood Marshall's first big case as a civil rights lawyer is a case against the University of Maryland. Mm-hmm. he has a friend, a younger friend, who sues, and Marshall succeeds in getting the courts of Maryland to say, well, there's not a black school in this state that's open to blacks who want to become lawyers. So the white school has got to admit, Murray versus Pearson, got to admit this black student. Justice Marshall, decades and decades and decades later, loved talking about that case and would always say, sweet revenge.
Very good.
Best served cold. It's interesting you note that he could not attend a school in his neighborhood, in essence, which really is one of the foundational circumstances that brings Brown to the fore. Young Linda Brown, 7 years old, in Topeka, Kansas, goes to a black school, but it's very far away from where she lives. She has to pass white school to do it, and her father chooses to attempt to enroll her in the white school. So we heard mentioned earlier, this is really a consolidation of multiple cases with similar circumstances. And in the case, Marshall goes directly at Plessy, yes? Tell us a little bit about his theory that separate is inherently unequal. That no matter how good the quality of the two schools, because by some analysis, the schools in Kansas happen to be quite similar. Even the plaintiffs would argue they were getting a good education at the black school. But there was this belief that they're inherently unequal.
Well,
you could start first.
So I'm going to answer this with a little story. The year I clerked for Justice Marshall, there was a lot of news about an effort to start a new public school academy for black boys. Yeah. And this sparked a lot of conversation in chambers among my co-clerks and him. And he basically said, he told this story about a separate unit in World War II. Like, which unit is going to be asked to go do the most dangerous mission? And he said, if there's a potential budget cut, he felt like a school like this would just make black kids vulnerable, which is going to be the first on the chopping block if there's going to be a budget cut. And so I kind of learned in that moment that he was concerned about equality, but he had a very pragmatic understanding. And this is a person who went to HBCUs. He believed in black excellence. He believed that people could thrive with the right resources. But he was, I think, pragmatic about the reality that separate actually almost never was equal and wasn't going to be equal in terms of access to resources. But I also, believe that he, like my parents' generation as well, he was my grandfather's generation. By the way, my Thurgood Marshall and my grandfather, Mark Carpenter, were fraternity brothers, along with Langston Hughes at Lincoln.
Oh, wow.
Alpha Phi Alpha. That helped me get the job in addition to his recommendation. But he believed that the caste system had to be dismantled, and he believed that the Equal Protection Clause demanded the dismantling of a caste system. So that's my understanding.
I agree with all of that. I would want to add, though, and here's where I think the mystification of segregation is actually still with us, because I think we're what's wrong with it? What's wrong with it? What's wrong with it? It was a purposeful insult. Mm-hmm. You use the word caste. What it was really about, and Harlan says this in his dissent in Plessy versus Ferguson, it was about protecting white people from contamination. Mm-hmm. It was a quarantining. That's what it was about. It was unilateral. It wasn't a negotiation. It was white people, the white power structure, calling the shots, putting black people not only apart, but down. If you go take a look at the statutes, what do the Jim Crow statutes actually say? One place you can take a look at this, by the way, a wonderful resource here is Pauli Murray's great collection of race laws in the United States in mid-20th century. And you read through these laws, and they say things like, in many of the states, to go back to Plessy versus Ferguson, railway cars, black people cannot sit with white people cannot sit with black people, but there is an exception. What's the exception?
Oh, yeah.
The servant.
Servants. You can have maids. You can have maids now, because it was understood. Well, if it's a maid, then, it's understood this person is lower. This was repression. This was insult. This was a way of putting black people down. And that's why it was inherently and unavoidably inconsistent with any sensible notion of equality in America.
So
And
this
it was
seems
also
so-
backed by virulent, nasty violence.
Yeah.
The slightest infraction, particularly by a black man, of the code could get you killed.
This seems so compelling to us today, but it was a pretty radical proposition to put before the court. Difficult to imagine how it was going to be proven. How did Marshall crack that?
They tried everything. We mentioned the long period. I mean, you take a look at their briefs. They were making various arguments. It shows they were up against so much. The racism was so deep, was so pervasive, that it was actually hard to make an imprint. And so they had to try various ways in which to try to reveal the unfairness. Now, on our side of things, it looks obvious, right? On our side of things, it seems so clearly unfair. But on that side of things, it did not. And the fact of the matter is that the segregationists had a lot going for them. The text of the Constitution does not expressly forbid government separating people on a racial basis. It just says, you just got to treat everybody with, equality before the law. Well, the segregationist says, well, segregation is equality before the law. So the text was ambiguous. If one turns to originalism is really big, right? Well, if you go back and take a look at, what were the framers and ratifiers of the 14th Amendment saying in 1868, there's a very strong argument that the majority of ratifiers and framers of the 14th Amendment did not intend to strike down segregation.
Or segregated schooling.
Segregated schooling.
Schools were segregated in the district, I believe.
They were,
Yeah,
and in fact, in most states where there was public schooling, there was a strong argument that, as an originalist matter, segregation, okay. Not to mention segregation with respect to matrimony. And then third, precedent. I mean, by 1954, there had been many, many, many cases in which courts, including the Supreme Court of the United States, had said segregation is compatible with the United States Constitution. So the segregationists had a strong argument.
So what got to the court?
So it's interesting. The Kenneth Clark Doll study seemed to, I don't know whether it
Tell people
persuaded
what that
him.
is.
Okay, so Kenneth and Mamie Clark, sociologists, had conducted a study.
In the 40s.
Right, in which and you can go watch videos of it, which they would put a black doll and a white doll in front of black children and ask questions, which is the nice doll, which is the beautiful doll. And tragically, a lot of black kids pointed to the white doll, but not all of them did. It's interesting. If you actually look at the data, black children in the North were more likely to point to the white doll than black children in segregated Southern schools. That said, you know, a large number of black kids were pointing to the doll. And I believe it was in the Briggs case, I think it was Robert Carter who introduced the Kenneth Clark study in the Briggs case at the lower level. It was either that...
Starts in Kansas, but then it does go in South Carolina as well.
Yeah, okay. So, you know, Earl Warren, former governor of California, former attorney general of California, was a politician. And he was trying to he wanted a unanimous opinion. And my guess is he found the doll study to be an empathetic way to bring people along. Why that stuck when other things didn't, you know. But the gravamen of the case, or what he says, is separate schools send a message that generates feelings of inferiority of black children that retards their development. The NAACP had argued in their brief about what segregation also did to white children. It inculcated feelings of superiority. They didn't talk about that, right? But for whatever reason, that was the central to the logic of why they said we can no longer have state-sponsored segregation of public education.
You know, I think that legal doctrine is important. I mean, that's how I pay my mortgage off. But I don't think it's actually, often it's not the most important thing. So if you ask me, you know, what is it that really gets us to Brown versus Board of Education, I would say things like World War II.
That's where I was going. Yeah, World War II.
Nazism puts a real stink on racism. And there are lots of people who say, well, gosh, there are a lot of people who died fighting Nazi racism. How can we fight Nazi racism and have Jim Crowism? I think I think that was important. Another argument. Number 42, Jackie Robinson. Popular people doing things in society and doing things in a fabulous way, a great way, breaking down barriers here and there. Marian Anderson. I mean, I think that there are various things that are happening in society that move people, move the politicians, and then finally move the jurists. I think, and then, the doctrinal stuff is often, that's the way in which people rationalize
what
the
they're ready to
decisions
do.
that they've already, made.
They're ready to do it, right.
Just like
now,
all
I'll say,
humans.
Russia also was embarrassing us. We have
the Cold War.
We have the Cold War
Cold War.
going on, and it's getting more and more inconvenient,
This is an interesting point. The Justice Department filed an amicus brief, and the vast majority of the amicus brief was actually related to foreign policy concerns. This is the Cold War, when the United States is running around the world fighting with Russia over whether countries will become democracies or communist countries. And what the U.S. is running into overseas is, how can you come here selling democracy when you have a country that has separate but equal? And it had become an embarrassment and a Cold War disadvantage. And it's fascinating to see the Justice Department comes in and says this is a foreign policy problem, which most people didn't realize. Earl Warren puts this thing together. Interesting fact, this case was argued in '52. The Chief Justice of the Supreme Court dies after oral argument Chief Justice Vinson, who was believed to be leaning toward dissenting. He dies and gives the president the opportunity to appoint a new justice who happens to be Earl Warren, an integrationist from California, who then comes on the court and leads this consensus. This opinion is remarkably concise. I thought it was 13 pages. I looked at the originals. It stops at 12. The internet's wrong. By the way, ChatGPT was wrong on this as well. Caution to everyone. Randall, I saw you write once that this was probably intentional and perhaps wise. But then you went on to say, but it rendered the opinion pallid.
Yeah.
What did you mean?
Well, Chief Justice Warren, right before, handing down the opinion, writes a memo to his colleagues describing what he's attempting to do. And he says, I want to write an opinion that is brief, write an opinion that regular people can read, and he says, and above all, write an opinion that is non-accusatory. Now, he wanted to write an opinion that was non-accusatory in large part because he wanted to preempt opposition. There were some members of the court, in particular, you mentioned Vincent, but Vincent had passed away, but then there was another member of the court, Justice Reed from Kentucky, who was very loath to give up segregation. Warren, however, wanted a unanimous court, and so he wanted to write an opinion that would get what he wanted, that is to say, the striking down of de jure segregation with respect to public schooling, but he wanted to lessen the amount of reaction against his opinion. So he writes his opinion. Like you said, it's a very short opinion. It's a very short opinion, and it's an odd opinion in the sense that, here we are at the National Archives, we're talking about this, we're talking about what a landmark opinion it is, but if you actually just read the opinion, if you didn't know about American history, you would not really know what the fighting is all about. You would not know, from reading this opinion, you would not know what segregation was about. Is racism in that opinion? No. Is the cruelty of segregation described in that opinion? No. Is the way in which separate but equal was administered in a grotesquely unfashioned way, is any of that mentioned? No. It's a very muted opinion, and one of the things, in fact, I would say the most striking aspect of this opinion is that this is the most honored race relations opinion delivered by the Supreme Court of the United States, and it is also an opinion that declines to candidly grapple with racism.
Mm-hmm.
Well,
Bring it on, Sheryll. Bring it on.
so I write about Brown as one of a trilogy. Okay, first of all, a couple things I want to bring out. The first federal court to take on, to say that separate was inherently equal was a case out of California, Mendez v. Westminster, I believe it is, but it involved litigation involving segregation of Latino students out in California. And I believe Warren was Attorney General at that time, right? So he, and as a result of that case, they end up changing the legislation. So Warren did have some experience with—
Governor.
Yeah, when he was governor. Okay.
Yeah.
He had some experience with integrating schools. So he wasn't integration, but I will say, as Attorney General, Warren supported the internment of Japanese people, right? So some ways I think of Brown as maybe his own personal atonement, He wasn't a great liberal during Japanese internment. So I just wanted to bring that out. But where I was going was that I think of Brown as part of a trilogy. Warren wrote 3 unanimous opinions. One that people don't talk about very much, a case called Texas v. Hernandez, decided 2 weeks before Brown. I do teach this class. Do you teach this case? Mm-hmm. Okay, all right. You didn't teach this case to me, though. I had to discover it on my own. But it was the first case to apply the Equal Protection Clause by the Supreme Court to Hispanic people. And basically, it was a case about excluding Hispanics from juries in Texas. So that's unanimous. And he says in that case that discrimination is not static. It comes in all forms. And the Equal Protection Clause should be available to anyone who's singled out for different treatment than from a community norm. He doesn't name the norm. It's whiteness, right? Then in Brown, another unanimous opinion. Yes, you could say it's pallid, but you know there are a couple of notes in there that I think are very patriotic that remind me a bit of the Declaration of Independence. It has some values you can grab onto, which is the idea that he talks about the public schoolhouse, the common public school, is so important to cultivating citizenship. I think this is as close as he can go to saying, white folks, you need to be part of this project. We all need to be part of this project of learning together and having common values. But it's only after a social revolution, civil rights movement, and I think the biggest lasting legacy of Brown is that it captured the imagination of young black people who said, hey, I'm free. I should be able to participate in whatever institutions the state is sponsoring on an equal basis. And that generation is willing to go, in 1,000 places within, 6-7 years, 1,000 sit-ins all over the place, right? Demanding to be free. But after that social revolution, by 1967, you get another unanimous opinion by Warren, Loving versus Virginia, in which he does name twice. It's the only Supreme Court opinion, the first and the last, in which they say this law is about white supremacy. And we can no longer, he's basically saying we can no longer square white supremacy, racial hierarchy with the Equal Protection Clause. Then he pretends, yes, this is revisionist, he pretends that it's not consistent with who we are. He makes it seem like the Supreme Court has always been, fighting that fight, when in fact, from the founding forward until Brown, until the Warren Court, the Supreme Court actually had acquiesced in, reified, reinforced racial hierarchy. Yes.
I was not putting Chief Justice Warren down. Mm-hmm. Chief Justice Warren was a great jurist and did a lot of good work. He was up against something.
Yeah, he was. I think he went as far as he could go, he was a
statesman,
and it was strategic.
Yes.
Yes.
So sometimes you can't say everything that's on your mind.
Right.
Sometimes obfuscation is actually a smart way to go, mm-hmm. and that's what he was doing. Brown versus Board of Education, his opinion, obfuscation, mm-hmm. and but he was up against it. And I would say to people, I think nowadays when people look at Brown versus Board of Education, they actually forget how bad things were.
Right.
And have forgotten the constraints under which those justices were working.
Let me put a pin in that. I want to encourage the audience. We're going to take questions if you're interested. If you are, make your way to the microphones. One thing that we haven't gotten into depth, though, that I think would be incomplete is the court didn't tell the country how to do it. And the years that followed were pretty bloody, pretty violent, the resistance pretty amazing. They closed the schools in Virginia instead of integrate. National Guards had to be called out. George Wallace famously standing on the steps. So very, very tough. And then we did get the Civil Rights Acts of 64 and 65 as a catalyst. Lots of questions. Sir, you're first.
Thank you so much for being here today. My name is Nathan White. I'm a recent graduate of Montgomery College here in the Washington, D.C. area. And thank you. And I'm hoping ultimately to teach civil rights and American history. And my question is, one aspect of the Briggs versus Elliott case that I found particularly interesting was the role of Judge Julius Wedis Waring and his relationship with Thurgood Marshall, and how Judge Waring really was quite important in making the case an attack on segregation as a whole. And I was wondering if you would be able to speak some about Judge Waring's role in the Briggs versus Elliott case and his relationship with Thurgood Marshall.
Succinctly.
Okay. Just quickly, Judge J. Wedis Waring was a white jurist. He was part of the upper crust of Charleston society. He had been a thoroughgoing segregationist, and then he had a total change of heart and mind, and went against segregation, and he dissented in Briggs versus Elliott, and in an opinion that is actually much more aggressive than Brown versus Board of Education, really does attack segregation. But what's so striking about this man, Judge Waring, is the turnabout, because he had been, thoroughly in league with the white supremacists of South Carolina, and then he becomes their nemesis. Great man.
Fascinating.
Yeah, hi, my name is Stephen Lincoln Spitz, born on February 12th, which is why Lincoln is my middle name, in Chicago. I have a question about whether or not there was evidence in the Brown case in Topeka that about the facilities, what was stipulated that, assuming the facilities are equal. And the reason I'm asking that question is when I was a lawyer across the mall at the Department of Health, Education, and Welfare, we got a lawsuit claiming that the schools in Topeka, Kansas, 73, were unequal in facilities and still segregated. And I personally went to all the junior high schools in 1973-74 with a facilities expert, and believe me, they were very unequal at the time. For example, the science labs had individual gas, electricity, fire in the white junior highs, but none of the black junior highs. So I was wondering what kind of evidence there was about the facilities in the time of the litigation in the 50s in Topeka.
My understanding is that all the lawyers were willing to stipulate that they were equal, even if they weren't, just so they could get to the question of whether separation was inherently unequal. But I'm not sure.
I think that in virtually in the cases, the way in which, for instance, in Kansas, in South Carolina, and in Virginia, the lower courts conceded that the black schools had been deprived of what was due to them. The courts conceded that, but what they were not willing to concede was the inherent invalidity of segregation. So, in South Carolina, the lower court said, fine, we're going to rule in favor of the NAACP, but in ruling in favor of the NAACP, we want equalization, not an end to segregation, but equalization. They did that in Kansas. They did that everywhere. And, that is that would have provided actually an out to the Supreme Court had they wanted to take it. But they had finally come to the conclusion that they were finally willing to grab the nettle and invalidate segregation.
Hello, my name's Gavin Neubauer. I'm a public policy student at the University of Maryland, so the fight was very interesting and personal to me. I wonder a lot about this, studying public policy and law, but how does it really change the culture? And it feels notable that in this country, a lot of it happened in the courts, and a lot of it still happens in the courts. But there's always this question about legitimacy, because it's not being passed in Congress. And there's always this fight, this backlash that happens after every major case, like that county in Virginia that shut down all of its public schools and gave vouchers to white kids. And I wonder, when, in the aftermath of a monumental case, when all the fighting is at its peak, what fight happens after that? What does it take? Because it seems like the dust settles eventually, but I know there's an incredible fight with law and smaller courts that happens afterwards. And I want to know more about that story when it comes to Brown v. Board of Education.
Well, very quickly, Brown doesn't get enforced until we get a social revolution that results in the Civil Rights Act of '64 that has a Title VI in which the federal government can withhold funding and threatens to withhold funding from school districts unless they desegregate. And that's what really gets desegregation started. So, there is something to this idea that, the Supreme Court doesn't have an army. There was massive resistance for more than a decade, right? So it took a social revolution and legislation passed by Congress to begin to give meaning to Brown.
I'd agree with that. On the, courts are very important. You mentioned the word legitimacy. Hugely important. When people, for instance, there are people who suggest that, well, Brown versus Board of Education didn't amount to much. I think they're totally wrong. On May 16th, 1954, it was legitimate for states, it was constitutionally legitimate for states to purposefully and openly separate people in schooling on a racial basis. Brown versus Board of Education comes down on May 17th. On May 18th, it is no longer legitimate for states to do that. That's hugely important. Legitimacy matters. It's not just in the courts, though. What changed things? Well, there were these great lawyers. That helped. There were the students who sat in. That helped. There were people who engaged in boycotts. That helped. There was Martin Luther King. There was Fannie Lou Hamer. There was Bayard Rustin. There was Malcolm X. There were people who were fighting the good fight in lots of different places. And that is required for society to change. It's not going to be just the courts, though the courts are important.
Yes, ma'am.
Hello, my name is Sakina. I have two, lighthearted one and then a serious one. The lighthearted one, would you consider Thurgood Marshall to be funny?
He was
Did he have a good
beyond
sense of
funny.
humor? Yes. Okay. Love that.
Very funny. He was the best storyteller. He could make you laugh so hard. Tears would be streaming down your face. He was delightful.
I love that. Okay. And then my serious question. With the climate that we're in right now, do you think there is a chance that Brown v. Board of Education could be overturned by the Supreme Court?
No.
As bad as things are, and I think things are actually very bad.
I agree.
But no, I think that Brown versus Board of Education has sunk such deep roots in American society that no, it's not going to be uprooted. Though, one cannot be complacent.
Yes.
one cannot be complacent. We have seen you began with the first Reconstruction. We began with the first Reconstruction. After all, during the first Reconstruction, there were black people who, during the first Reconstruction, the senator from Mississippi was a black man.
Right. Right.
Lots of things changed in the first Reconstruction. It was rolled back. Things can go backwards. So we cannot be complacent. I do think, however, that Brown versus Board of Education, thank goodness, remains vital.
Well, let me say this. The values of Brown are betrayed every day in this country.
Yes.
Right? Everybody in this room knows that we have separate and savagely unequal schools, and parents work really hard to avoid the low-performing, not very good schools, right? So, the Roberts Court would never overturn Brown. I think, Roberts is very proud of the progress. He touts Brown as great social progress. But conservative justices and far-right, I would say extremist elements in this country, they have reduced Brown to a requirement for colorblindness, a requirement that all it does is say the state cannot use racial classifications, right? And so they read it in a narrow way in which it makes it a lot harder for any state to engage in repair, a race-conscious kind of repair, right? So Brown has been limited and undermined, but the fundamental principle that we will not have state-sanctioned racial caste, I don't see that being overturned.
Thank
Riley
you.
Temple.
Thank you. If we are limiting our discussion to Brown as a function of or having the desire to increase the quality of public education, how would you assess today Brown's success or failure?
We're putting a lot of weight on one case.
By the way, before you answer, because I have more notes, yesterday I read an Axios article. The headline was, "School Segregation Surging After 70 Years." The article said that the number of intensely segregated schools, defined as schools that are 90 to 100% non-white students, have tripled from 1988 to 2021, according to a UCLA analysis. So in some ways, we have a lot of work still to do.
I think we do have a lot of work to do. I think that people use, I think people are a little bit too loose in their language. So that article, and there are many articles that say things like, there's as much school segregation now as, in 1954. No. I think we ought to remember exactly what it was that Brown versus Board of Education was targeting. In 1954, in South Carolina, the state constitution of South Carolina said that white and colored children were to be educated in different facilities forever. That is what Brown versus Board of Education was targeting. Now, again, yes, there are lots of problems in the United States, but I would set forth the following proposition. There is no place in the United States today, where a government can say with proper authority that it is purposefully separating people on a racial basis. That was an accomplishment. It was an important accomplishment. And, you know, I don't think it should be, it wasn't a little thing. It was a major thing. It has its limits. Is that, you know, does that bring us social equality in full? Of course not. But it was an accomplishment, and we need to be very clear about that.
So I just want to quickly say, I agree with everything Randy said, but, and I read that article too because my husband put it in my face, right, the Axios, right? And the stat from that jumped out at me, the Axios piece, is that the average existence for a Black or Latino child in public education today is one where 3/4 of their peers are minority, and you know, according to the Civil Rights Institute project out at UCLA, at least half of their peers are poor. Often it's a lot more than that, right? And meanwhile, the average experience for white and Asian children is the opposite. They tend to be in middle-class schools, right, that are better resourced. In my view, that's a caste system, right? It's no longer like, it's no longer required in the state constitution, but I gotta tell you, you know, there's a lot of publicly sanctioned policies that encourage rather than discourage this type of systemic segregation. So.
Yes, sir, we're getting to the end here. Let's get the last question.
First, thank you for a great discussion on Brown. It's great seeing my colleague.
Thank you, Mike. This is my colleague, Everett Bellamy.
Everett Bellamy. I served as a dean at Georgetown Law. I was a dean
Yes, you
when
were.
Chairman Powell was a student.
When I got in trouble, they would send me to him.
So great to see you here. Could you take a moment, please, to talk about the second Brown, Brown 2, which was decided in 1955, the next year. And Chairman Powell, you talked about the resistance to Brown and the backlash and all white schools being established and so private white schools being established. The need for Brown 2, which, and you talking about Brown 1 being short, Brown 2 was real short. What is the phrase? With all deliberate speed? Could you please comment on the need for that?
Justice Marshall liked to tell this story. When Brown 2 came down and said all deliberate speed, the secretary got the dictionary and looked it up and said deliberate, it means slow.
Right.
And there you have it.
Right. Move slow. And we've been moving slow.
Last question.
Good evening. My name is Solomon Palmer, and I'm just an ordinary person who serves an extraordinary God, period. With that said, I've always been fascinated by the unanimous decision. Dred Scott, dissent. Plessy, dissent. But Brown, dissent. And I want to suggest also the role that I believe and can argue, based on Brother Charles Ogletree's book, makes the argument that faith played in it. Because Oliver Brown was a minister of the AME Church in Topeka, Kansas. So can we speak to, for us this evening, what role faith could also have possible in determining for the first time a unanimous decision? Thank you.
I'm gonna let you have that one.
Well, sir, the matter of unanimity is an important aspect of Brown. The Chief Justice Warren, really thought that it was very important. Justice Marshall thought it was very important to have a unanimous court. There are people who more recently have questioned that, and I think there's good reason to question it. Could it be that Chief Justice Warren paid too high a price for unanimity? I mean, after all, there are a lot of Supreme Court cases that are not unanimous, but 5 votes and you have the Supreme Court. Would it have been better maybe, think about this as a sort of a counterfactual. Let's suppose the Supreme Court, instead of going the gradualistic route, Brown 2, for instance, just suppose the Supreme Court had said, no, we want immediate desegregation, and just suppose the Supreme Court had been very forthright and candid and clear in its denunciation of segregation. And let's suppose there had been some justices who would have dissented. Would that have been so terrible? It seems to me I could easily imagine a scenario in which, no, it wouldn't have been so terrible. Maybe that would have been a better route to have gone. I don't think that we should view unanimity as sort of an untouchable. It's what we got. Maybe it was a good thing. On the other hand, there are alternatives that are certainly plausible.
You could have had another Worcester versus Georgia, though. You remember, there was a famous case in which...
Wouldn't you say that we did get that?
Yeah, you're right, we did. It was unanimous.
Let us in on this case.
Oh, sorry. Worcester versus Georgia involved the Cherokee tribe it was one of the Cherokee cases out of Georgia, and Chief Justice Marshall wrote a very pro-Cherokee opinion and sided with them, and Georgia just ignored it. And the apocryphal story is that the president said, you have your opinion, let you enforce it, right? So, but we did have massive resistance, right?
So we're coming to the end of the evening, and I just want to give each of you a final reflection on the legacy of this case and/or the extraordinary example that Thurgood Marshall gave us. Sheryl, do you want to go first? Or?
You go first.
Well,
I have to think about it.
Just a couple things. Number one, I'd like to thank very much the sponsors of this evening. It's been certainly a privilege for me, and one can only applaud civic events like this in which we get to trade ideas and trade information. So I'm very grateful. With respect to, if there was one thing that I'd like to leave people with, the Thurgood Marshall's name has been mentioned over and over, and it should be. It should be. If there was one person, if you just had to choose one person who would be the exemplar of struggle for racial justice under law, that person would be Thurgood Marshall. And this case would be probably the most important of the cases that he helped to bequeath to us. So thank you.
I want to thank the sponsors too. It's been it's such an honor to be here and get to talk about this in front of my twin sons. Force them to listen to me.
They're like, why did you do that?
Embarrass them. Right. They're both in advanced U.S. history and doing well. The story I want to leave you with, it's kind of painful. I clerked for Justice Marshall in his last active year on the court, and we had a case that year involving the city of Oklahoma's school district, a case called Dowell, Oklahoma City versus Dowell. And I think it's okay for me to say I supported him. All the clerks supported him in this case. But I got to see him in his, we didn't know then that this was his last active year on the court. First week, Brennan retired. My first week on the job, and my last week on the job, Justice Marshall retired. But I watched him struggle to convince his colleagues not to send the message that it was time to stop desegregating schools. Dowell was trying to get out from under a desegregation order. They had waited 18 years to enforce Brown and had integrated schools for a very brief period and wanted it to be declared unitarian and get out from under it. And in chambers, he was very upset. He practiced aloud with us the things he would say in conference. And he was partially effective. His colleagues adored him. They really, I mean, one of his best friends on the court was Antonin Scalia. Scalia would come and talk to him, you know. But they waited until he died. I mean, in that case, they kind of just hinted at what would be necessary to stop enforcing desegregation orders. They waited until he died. But in the 90s, in a series of cases, culminating in Missouri versus Jenkins, basically the court said, to the extent that school segregation patterns just reflect segregated neighborhoods, that's not the school district's fault. And so we will no longer force them to have integration plans to overcome residential segregation. And that's the main reason we have rapidly resegregated. And Justice Marshall was devastated, but the day after the opinion came down, he came back in the office, his jolly self, you know, and his attitude was, you know, each generation has to just pick up the fight. So you young people in the room, you got to pick up the fight.
Amen. Well said.